underway. A very warm welcome to all those of you who are joining us. This is the third of our live webinar series, and they are proving a very popular way of keeping the community and keeping us as a group together. This morning's session is with the team from William Fry. You can see them gathered before you now. A very warm welcome to Catherine O'Flynn, to Derek Hegarty, and to Paddy Murphy, all of whom specialise in both the sports side of it for Paddy and Derek, and Catherine is joining us today with a particular reference to the employment side of it, which I think is going to be very important. Just a few little housekeeping rules, I guess, or suggestions. If you look to the top right-hand corner of your screen, you'll see a toggle button for gallery view and speaker view. And if you toggle to the gallery view, it gives you the optimum viewing experience for seeing all four of us on screen at the same time and having the conversation. There is a chat facility down in the bottom of your screen, just over towards the right of those various different little buttons down there, and there is a Q&A facility which I hope you will use. I've no doubt that we will cover most of the questions that you have, but certainly not all. And if you do want an opportunity to pose a question and answer, we will have time at the end of this session as well. Really, just as a preface to what we're saying today, and I hope you'll understand the reasons why, but both in law and in advisory, we do need to be a little bit careful that both myself and the William Fry team would have a number of different clients and members, many of you who are in the room with us today, and please don't take anything that we say today as being in any way related to advice which we may have given to clients. We will be very independent and we will be very honest, but please don't take something that we've said as being, oh God, well that's what the advice was that they were giving to, because obviously that's not something that we would be able to make available. That's probably a clunky way of saying it, but it is important to note. And we're gonna kick off this morning session now with asking possibly a question which has popped into most of our minds over the last couple of weeks, some of whom have got an idea of what it means, but the phrase of force majeure is probably a French phrase which has taken over much of our thinking, at least during our working days. Derek, what exactly is force majeure and how can it be relevant to the situation that we're in today with regard to sport and sponsorship?
Sure, thanks, Rob. So, as you've said, it's something we've heard a lot about recently and something we haven't heard a lot about for a very long time. A lot of the case law on this concerns Edward VII's coronation. So to give you an idea about when it, how infrequently it surfaces as a major issue. But when it does, it is very serious, as it is in this context. So it is important to have an understanding about what it can do and also its limitations. It is, to use to place it in a sporting context, it is a defensive measure. It's not for attack. So what it does is, if it is in a contract, and that's a really important piece, if there's a force majeure provision in a contract, then it can entitle parties to protection. Okay, so how it works, Rob, is that if there's a force majeure provision in a contract and a party relies on it, right? So the party will typically put forward a position to say, I undertook, let's say I'm a rights holder, to put a tournament on, to run a league, to run a Formula One a tournament event. I now can't do that. Now I contracted with you, a broadcaster, a sponsor, whoever it is. And under our agreement, I said I would put this on, and you said you would pay me money. Now, you've paid me money already, and you owe me some more money. I now can't put this on, okay? Now, I'm relying on the force majeure provision of our agreement. So when we made our agreement, we said that we would each perform our obligations, okay, unless a force majeure event happened. And I'm saying now, if I'm the party relying on it, that a force majeure event has happened. So where does that get me, right? Well, where it gets me is it gets me protected. So if in a year's time, in 6 months' time, in 2 years' time, I'm facing a high court action for the return of that money in that example from the broadcaster, the sponsor, whoever it might be, I will be able to say, hang on, I relied on the force majeure provision. We agreed when we entered into it that if something like this happened, that either of us could rely on it, and I did that. Okay,
Okay,
so
so does
so
it?
in its essence, that's what it is.
Yeah. So does when you say about protection, does that mean that that you don't necessarily have to then complete the tournament in order to have still the same full payment of rights from sponsors or broadcasts?
Well, so what you got to do under almost all of the agreements that contain force majeure provisions is you have to try and mitigate the effect of the event. So if the force majeure event is a public health response to a pandemic, which says you can't host events with more than X people at it, which means you can't host the tournament, you can't complete the matches, then yes, you're going to rely on that. Whether or not it's going to be sufficient to compel the other party, and if you're a broadcaster or a sponsor, you may well take the view, well, I've already paid you money. We got through early rounds of a tournament. The reason I'm involved is for the later rounds. I'm not going to keep paying you. So well, let's have a discussion on where we go from here. But then it comes back to that mitigation point. If you're going to rely on force majeure, you have to take the running on the mitigation. Now, mitigation in this context is let's find a way to put it on at a later date if we can. Sometimes you can't, depending on the nature of the tournament, the amount of games left, the required rest period, the logistics, if it's Formula One, say, it just might be rendered impossible. But that word impossible is important here. There'll be varying degrees of discomfort caused by the measures brought in by this government and governments in other countries for parties to sporting agreements. So there will be those that are rendered that have their ability to perform their rights rendered just impossible. So if you're supposed to put on a match with 80,000 people in it in Europe right now, with very few exceptions, that is impossible. If your obligation under your agreement as the rights holder is to make that happen for people to broadcast and for sponsors to avail of, you're going to say that is now impossible because of this. And if you have a force majeure provision in your contract, you're going to say, like, I'm relying on this now, which means you, my partner, my broadcast partner, if you sue me, I'm going to use this as a full defense. And that's really the top and bottom of force majeure. Like that's your best day out if you're playing that card. But equally, you got to think about it if you're the recipient of a force majeure notice. What does it mean? Well, it doesn't mean anything today. Is the shortest way to answer that. It doesn't mean that the contract is now over, that you're at war. Not at all. It just means that something that you already agreed to is now happening, but it need not change your relationship with your counterparty. And what we're advising people who are serving them is to bear that in mind. So in many sporting industries, when this ends, counterparties are going to have to get back into bed together. That you're going to be doing business with the same people. So, it's in your interests in many occasions to outline to them, look, we've got to serve these things, these notices, but we've also got to work with you to mitigate the effect of what's happened here. We're only serving them to protect ourselves. Nothing needs to change.
With so many of our the bigger sporting events spread across multiple jurisdictions now, does it make a difference as to where the contract actually sits? Because we've got tournaments that might be run by UEFA or the European Professional Rugby, both of which will be based in Switzerland, technically outside of the European Union. You might have contracts that will be signed in Ireland or in the UK. It's a global issue now, so everybody is more or less in the same boat. But if the boat is coming back to life a little bit quicker in some countries, is that likely to have an impact as well?
It is, Rob. Yeah, I mean, where the contract is located, for want of a better expression, so under what jurisdiction the contract is subject to, is more relevant if it's been litigated. Okay, but the relevance of the other jurisdictions is if that's where the decision is taken. So if you have a tournament that reaches into 4 or 5 different jurisdictions, or if it's a worldwide event, or league, and it touches on many different jurisdictions, then the reason why it can't take place in each of those jurisdictions becomes the subject of the decision of that government. Now, this is somewhat academic at the moment, because they're just, in a general sense, there's a blanket ban everywhere. So there isn't pockets of the world where you can go and host your tournaments. It's impossible everywhere right now. That wasn't the case 6 weeks ago, and we had different approaches by different governments. So we had a different approach by the UK government at a time when certain events, leagues, one-off matches were postponed. So there will be some differences there, and those same differences may become relevant when restrictions are eased. But it comes back to the same point that we made earlier. If those measures, those public health measures in any jurisdiction, make it impossible for you to discharge your obligation, so if your obligation is to put on a match or an event, then that entitles you to rely on force majeure for the most part.
We did hear some strange tales coming out of the UK last night that the Premier League were considering finishing out the season in China, for example. So that I think there's an awful lot of speculation around it at the moment. I tell you, we will come back to this, and particularly in relation to sponsorship agreements as well. There has been much talk that we live in unprecedented times, but the law is all about precedent. Paddy, are there precedents since Edward VII's abdication as to how this might apply that would actually be relevant in a court of law?
Hi, Rob. Yeah, there's actually a very recent or a relatively recent precedent from the African Cup of Nations in 2015. Morocco were due to host the African Cup of Nations that year, and this was during the Ebola outbreak. So about 2 months before the competition was due to take place, noticed that they weren't going to hold the competition, and it was subsequently held by Equatorial Guinea. Now, this put them in a difficult position because they were obliged under their host agreement to host the tournament. The African Confederation, the Confederation of African Football, subsequently brought proceedings against them, and the Morocco tried to rely on the force majeure clause in the contract to avoid their obligation, and that obligation being to host the event. And that was rejected by the Court of Arbitration. This is pretty much relying on expert evidence that said the Ebola outbreak at the time could only be transmitted through direct contact with bodily fluids, which would be different from the current COVID-19 pandemic that seems to be transmitted through the air or touch. So as a result of that, they said that the tournament wasn't actually impossible to hold, that it was just practically difficult, implying that Morocco could have held the tournament if they put in sufficient precautions. And it's just notwithstanding that decision, the Court of Arbitration for Sport were actually relatively sympathetic to Morocco, and they overturned a ban from participating in the African Nations Cup, which had been placed on them by the Confederation. But I think it's a pretty unique case in the circumstances of Ebola and its characteristics. And if a similar case arise now for the complete cancellation of the competition, I think the competition organizer would be in a stronger position to rely on a force majeure clause. Okay,
and looking closer to home, the Six Nations, or the Guinness Six Nations as it is now, it wasn't then back in 2001, during foot and mouth disease, there was quite a lot of shifting and changing, and maybe in our best case scenario we will get to finish out all of the tournaments and competitions. Was there anything that arose then that might be relevant in now nearly 20 years on?
No, there wasn't any litigation that arose. The Six Nations, in fact, was one of the only tournaments that was really affected. I think Cheltenham was cancelled too, but the Six Nations matches were moved. The last 3 matches were moved to September from February, and the Six Nations was completed then. But it demonstrates like what Derek was mentioning earlier, the fact that the event organizer has to mitigate the effects of the particular force majeure event. I think this is an example we can see with the Premier League in England at the moment, where they're looking at proposals, like you said, to play it in China, to defer the season until July or August, to hold games behind closed doors. And they're all options that they have to pursue, given that the alternative is to cancel the league altogether.
Okay, if I can come back to you just briefly, Derek, for a moment. One of the stories we had this morning was talking about this potential breakdown already of relationship between broadcasters and sporting organisations. IMG, one of the biggest rights agencies, are understood to be withholding payment for the FA Cup rights going to the FA, which is 100 million a season. DAZN, the streaming company as well, has already begun to issue notice that it will not be fulfilling some of its obligations. Is it in broadcast rather than sponsorship that this is going to be felt first, if it is felt beyond where we're at the moment?
That's probably going to be determined just by numbers, Rob, and the numbers are generally larger in broadcast. So that's probably motivating broadcasters to look at that first. What I would say on that, though, is it's a tougher line to successfully run if you're a broadcaster, to say that I'm relying on force majeure, like this is a force majeure event. Because let's think about what's the broadcaster's typical obligations under an agreement with a rights holder. It's to pay money. So it might be more difficult for you to pay the money, but it's not impossible, would be what you would respond with to that. So in those instances, it is less likely that a broadcaster will try and rely on force majeure, because to do that, they're going to have to say, it is now an impossibility that I can do what I said I would do, which is to make a payment to you. I might have greater difficulty getting the money, but if you're arguing the other side of that, you'd say, well, that's for you. It's not impossible for you to pay me. Now, what you'll see there, and this is something we can deal with later if people want, is there's a doctrine of frustration, which I would imagine broadcasters will seek to rely on there if they're going to run that line, or at least they'll consider it, which essentially is a doctrine under lots of legal systems. We have it in Ireland, and it says, look, if circumstances arise which make performance of the contract impossible, then the contract is over and each party can walk away without further liability. That's a very crude big picture description of it, but if I was for a broadcaster there, I'd be certainly exploring that. It might look at force majeure, but it's a more difficult one to bring home there. If your only obligation is to transfer money, then, well, it's not directly made impossible. It might be made a hell of a lot more difficult.
We might come back and touch on that. All right. The doctrine of frustration sounds something like out of a Dante novel from the Middle Ages. Wonderfully arcane, but
start your Wi-Fi router when you're trying to work from home. But
it's a possibility as well. I want to come to you now, Catherine. One of the issues that might still arise out of this idea of playing behind closed doors or playing tournaments in Japan and things like that is the players and the rights of them as an employee. Now, we've been fortunate thus far in that the government acted quickly to move towards offering pandemic payments through the revenue, which many companies, including perhaps many of them that are in the room with us today, and indeed sporting organisations, a number of the SSE Airtricity League clubs, that it's kept them afloat by going through that. Where is the legal position in relation to all of that? I know it's unusual sometimes to think of revenue as our friend, albeit they are our friend at all times. But in this case, it could be quite complicated, or is it? Is it something that we should be fully on top of?
Yeah, I mean, from an employment perspective, you know, the situation is so unprecedented in terms of keeping our employees in employment. We haven't come across this situation before. I mean, it was a bit like this back in 2008, 2009, I guess, was the last time we were looking at really widespread layoff in short time. But employers haven't really had to grapple with these issues for a while to such a large extent. So, as you say, all employers across the board, to include sporting organisations, have really had to look at their workforce over the last couple of weeks. Usually the main objective is to keep people employed. Obviously redundancies, even layoffs, we would hope that would be the last resort. And so that's where the government has come in. And last week they published the emergency measures in the Public Interest Act, which brought about the measures such as the temporary wage subsidy scheme, which has been of vital importance to a lot of employers. Been lots of commentary about it in terms of how it works. It's not the most user-friendly. So there has been a lot of revenue guidance. So I guess that's where you talk about the revenue being our friend. It's really important for employers to become familiar with what the revenue is saying in their guidance as to how that scheme works. Because that's really what employers need to be doing now. They need to be planning ahead. They need to be constantly reviewing the situation because it is changing. I mean, it's been changing day on day in the last while in terms of employment benefits and developments. Seems to be settling a little bit now. So now is the time that employers can really get familiar with what benefits are available to them. And the hopes really are that, you know, with the use of those benefits and planning ahead, that you want to keep your employees on the payroll so that, you know, when things get going again, when the opportunity permits, we'll be able to hit the ground running. So that's where it's so important. And, you know, organisations and people who are involved this morning on the webinar who have employees both in the UK and Ireland, you need to be careful. There are, you know, big differences between how the benefits work in Ireland as distinct from the UK. So, you know, we've all become really familiar with this term of furloughing our staff. I'd never heard of the word a couple of weeks ago, and now we're experts in how to furlough people. In the UK, if someone is furloughed, they can't carry out any duties. Whereas in Ireland, if they're on the subsidy scheme, they can carry out duties. They can carry out all their duties or some of their duties. So there's just kind of one example of how the benefits are different depending on whether your employees are in the UK or Ireland. So, you know, it's a lot for employers to take on board, that's for sure.
Okay, and there will be, you know, there will be an awful lot of different ways in which people are doing it. You know, we've seen, for example, how Liverpool, you know, football club have gone from heroes to zeros over the space of 24 hours. Now they've stepped back from furloughing all of their own non-playing staff. But it is imperative that all of the organisations actually do it and to as great an extent as possible do the right thing. So we've seen the IRFU, the GAA, the FAI, all of whom have instigated you know, wage deferral schemes and you know, nicely sort of scaled so that it affects those who need the money most the least. Is that case of doing the right thing, that should be your driving principle on this, shouldn't it?
Yeah, I mean, I think in all walks of life, that's a great mantra to live by, for sure. And in terms of pay cuts and deferrals and things like that, doing the right thing will involve getting out the employment contracts, seeing what they say in terms of pay cuts or deferrals, or see what they say about bonus schemes. A lot of sporting organisations are unionised, so it's talking to the union, checking collective agreements. So absolutely doing the right thing, but make sure that you're doing the right thing within the confines of what those agreements say as well. And taking the Liverpool Football Club as an example, in Ireland, the test is different in the UK as well. To avail of the subsidy, you have to show a 25% decline in profits or turnover. So it'd be interesting if Liverpool would have been able to avail of the scheme in Ireland. It's kind of questionable. But that's probably one of the trickiest things for employers in Ireland to have gotten their head around. It's that test. So yeah, absolutely do the right thing, but make sure that you check what the regulations say and the guidance say in order to do that.
Okay, and in relation to that, like the 25% drop, is that over a period of time, or is it over your financial year, or do we know that?
Yeah, so it wasn't quite clear from the Act. It was quite stark. You know, it talked about a 25% decline in turnover or customer orders. So the revenue have given some guidance since. And they say it's a projected forecast. If it turns out in the future that it wasn't exactly 25%, they won't come after you, they've said, necessarily. So there is a bit of a leeway being communicated to us from the revenue in that regard. They do talk about, you know, work out how it's sensible for you to work out what that means for you as a business. You might compare quarter 2 2020 as against quarter 2 2019, or some other sensible approach can be taken.
Okay, excellent, very good. We can come back to you, Derek. That sense of goodwill and doing the right thing, there's been a huge amount of that over the course of the first number of weeks of this, that everybody, we're digging into this together and we're doing the right thing by each other. The law is a little bit starker though than this sort of collective sense of goodwill and and bonhomie almost. Is that likely to be something that actually sort of, comes out of this, even that if we think we want to do things the right way, that we might not actually be able to because of the law?
Possibly, but I think for me, the most important point on that is to bear in mind that it should just be an absolute last resort. If we're going to litigate this stuff, it's going to take a long time. There isn't a huge amount of relevant precedents. And even if we are litigating, it's always going to be in our favor if we've made reasonable attempts to prevent the litigation. So what I would say to people listening is, if you're in a scenario where either you might want to rely on force majeure, or somebody that you're in a contract with wants to rely on it or wants to withhold payments, you got to talk to each other. You got to try and mitigate it, try and find a solution. This is tricky stuff. If you're going to litigate this, it's going to be costly, and it's going to be less predictable than other forms of litigation where there's well-beaten tracks to follow. So yeah, I agree. I think people are being sensible about it in extremely difficult times, but I think that is the biggest takeaway. It's in everyone's interest to keep doing that and to avoid sort of the brinkmanship that can come with proceedings. Just one last point on that, Rob. I'll just remind people that serving force majeure, if it's relevant to you, and if when you're preparing your agreement with your counterparties, you agreed to have this in it and you took the trouble to put it in, and you can now avail of it, then you should try and do that, but in a way that doesn't necessarily terminate any goodwill between you. So that may involve just explaining to the other party, look, I got it, as I mentioned earlier, I've been advised we have to serve these notices. They're part of our agreement. It shouldn't change anything between us. We should still keep trying to work around this, find solutions. You can still have those discussions even after you serve a notice. I would say it's good practice to do that. Okay.
A lot of the discussion that we've had today is of necessity in broad general terms, but companies with big sponsorships, rights holders on the other side of the fence of it, and broadcasters, all of us are having these discussions internally and externally with advisors as well. And I don't want this to come across as particularly negative, but if we are testing out different scenarios and scenario planning, is that, if we're doing that with our agencies and and even internally within ourselves, are those discussions potentially going to be subpoenaed? I'm watching too many American cop shows on the television, but are those discussions likely to be part of any case if this comes to that point?
Yeah, well, just typically, if under Irish law and UK law, if proceedings are issued, it's incumbent upon each side to exchange all relevant documents that they have. So all records of relevant communications should go to the other side. The general rule being, look, each side should see the other side's hand. There shouldn't be any kind of ambush trials, ambush tactics. Everyone should see what the other side is holding, and that might drive settlements earlier. So that's the general rule. So it's just worth bearing in mind, if it's a particularly sensitive piece of advice, particularly if it is legal advice, there is a doctrine of legal professional privilege which would allow you to withhold that if it's requested by the other side. So if it's something you would have to give to the other side, but it meets the test for legal professional privilege, then you'll be allowed to withhold it. That generally involves, not always, but generally involves either asking for or being or receiving legal advice. So just something to bear in mind.
Okay, so even though we're not able to actually have meetings about these things, that if we do have it on Zoom or Microsoft Teams or anything like that, we should have one of you in the room with us as well. So that would give us a little bit of a blanket of security. I'm conscious of time now. We're at the 30 minutes. Thank you everybody for listening in and joining us. The Q&A facility is down there, and I would encourage you to actually sort of to come in and ask any questions in, as I'd suggest, in a general form as opposed to anything specifically legal, because it is an open forum. Just coming back on that doctrine of frustration, Derek, which I love the sound of it. Can we just tease that out a little bit more, just in terms of how it actually sort of could be applied?
Yeah, so it's worth bearing in mind that the force majeure piece, which we've been talking about, that's only relevant if it's in your contract. It's not in every contract. So not every contract will make provision for a force majeure event. Some just don't have it in it. I suspect most will from now on, but contracts entered into recently might not have it as part of the contract. So there is no prospect of relying on force majeure if that's the case. So it is a contract specific entitlement. If it's not in your contract, you can't avail of it. Okay, you have to have agreed it with the other party as part of your contract. If you haven't done that, then you might want to look at frustration. That is a legal doctrine, so that's available irrespective of whether or not you make any reference to it in your contract. Okay, the bar for it is unsurprisingly very, very high. Okay, and events and scenarios that we might think look to have been frustrated, the court is likely to take a much narrower, harder view of that. So if you think of just an example, that there was supposed to be a league final which is supposed to be played in April, let's say, or a quarterfinal of rounds of quarterfinals of a tournament, and they can now be played. If the one party to an agreement, let's say between a sponsor and a rights holder there, one party was to rely on the doctrine of frustration to say, this agreement between us, it doesn't have a force majeure provision in it. If it did, I'd be relying on it, but it doesn't. So now I'm asking the court to allow me out of this contract, and allow me not to, let's say, pay any more money, because it has been frustrated. But what the court will say typically is, well, has it been frustrated? So has it been rendered impossible for the parties to achieve what was envisaged under the contract? So that was to hold, let's say, in its broadest sense, that was to hold a series of matches, which would, reduce the remaining teams in the tournament. Can that not be held in July, August? Can it not be held behind closed doors in August? Is it an impossibility? Now, it might be, because players might be out of contract in July. It might be for various other reasons specific to the thing we're talking about. But that's typically where you would try and rely on frustration, and that's typically how the court will assess it, in the most narrow form available. So you're going to have to reach a really high bar to win under frustration. Another instance where you can see frustration happening is again as a defense, to a force majeure notice. So force majeure notice gets served on a party. They take the view, probably correctly, that they can't rely on force majeure. Let's say their only obligation is to make a payment. It's still technically possible for them to make a payment. They mightn't have any money. It might be harder for them to gather the money to make the payment. And maybe they want to run that line that it is indirectly now impossible, but they might also want to consider whether they can make a claim successfully, that in effect the contract has been frustrated. There is no game for them to broadcast. There is no tournament for them to sponsor anymore. Therefore, they shouldn't be made complete the payments. And in fact, they're bringing a claim to get some of their money back, possibly. But that's the type of scenarios that you'd look at frustration in, typically in this sporting context.
Okay, we've got our first question in from Noel Martin from Core. Noel is actually going to be running our Thursday live webinar session on data and measurement in sponsorship. But very interesting question. We're looking at what's there in place at the moment, but Noel is looking to see how is this likely to affect the structure of contracts going forward, and whether we are likely to see any difference, apart obviously from spell checking Majeur, which is MAJEUR.
Well, just a sort of an obvious one, but I don't think we're going to find too many contracts in sporting industry without a force majeure provision in them after this. I think insurance will become a bigger feature in people's minds when they're entering into it. I think there'll be pressure on insurers to provide for as yet unforeseen types of pandemic, and not to rely on narrow interpretations. And yeah, I think they're the main piece. I think people will be much clearer that if these types of events, not necessarily being overly prescriptive of what the event is, but if these type of events happen, then this is what we're going to do. This is how we'll deal with monies already paid. This is how so you might see a greater level of prescription and almost scenario planning in contracts. That might be something that comes out of it.
Okay, so all of the stuff that we wish we had done, we will make sure that we do in advance of the next one. That kind of makes sense. The thing that's scaring me most about all of this is actually the prospect of COVID-20, but we won't go there. I don't want us to finish on a negative. There's, I've really enjoyed this. I think this is a really important discussion, and it's something which is never going to be resolved by burying our heads in the sand. So I know we've got big sponsors, we've got big rights holders that are in the room, and I think I'd take your word as well about going and talking to them. But if I could ask for each of you to just give us one word of, well, not one word, but something that you think will actually sort of be important from your perspective as legal advisors over the course of this, as we move from the preparation to the lockdown to hopefully the revival of normal activity. If I can kick off with you, Catherine, if there was one word of comfort that you had for the room this morning.
Well, I think, back to your kind of doing the right thing. A lot of our employees are working from home now. So we really need, leaving aside the financial issues for the moment, which are really important, but to leave them aside for one moment, we need to think about how we're going to look after those employees to make sure that when we do get back up and running, we're all ready to go, So an employer has obligations towards its employees when they're working at home, just as if they would if they were in the office. So we really need to focus on their health and well-being from home, particularly their mental health. How do we keep them engaged? How do we engage with them? And I think sporting organizations are probably best placed to do this out of everyone, because how vital things like sport and diet and mental health are to everyone, and also in terms of your audience and your fans, you can communicate those great messages to them. So looking after your brand while we get through this crisis, I think would be a great thing to do.
Yeah, that's great. Yeah, to look after people's well-being, very much so. Our 30 under 30 candidate this morning was Kate McDade, who's a nutritionist. Yeah. She'll be able to hook up with her other 30 under 30 candidate, who's Paddy, and they're in Tipperary. Paddy, your word of comfort for us.
Yeah, I think the most important thing we've experienced, Rob, is that both parties to a contract, and certainly the clients that are coming to us, while they're trying to establish position, their legal position, they're really looking to negotiate with the counterparty, and they realise that the counterparty is a partner for them going forward, and that's probably not something that's going to change over the next few months. So the importance of keeping a relationship with other partners is probably the most important aspect that should come out of this.
Okay, very good. And the last word to you, Derek, on this.
Yeah, I suppose just to say, we understand how incredibly difficult we're dealing with lots of clients in lots of different industries, just given the nature of what we do. We understand how incredibly difficult it is for businesses, and just how disconcerting this all can be. What I would say, just on the point that I've been covering mostly, which is force majeure, I honestly wouldn't, I wouldn't see it as overly negative if I get sent a force majeure notice by a counterparty. Don't read it as an escalation of aggression. Similarly, if you send it, it's worth communicating that to the other side. It's what happens at this time in these type of events. It shouldn't be seen as a pivot point in the relationship necessarily. So yeah, I would just view them as part of what's happening at the moment. They are being served, they are being issued, they're being received, but they need not change the relationship between the parties.
Okay. Well, thanks very much to each of the three of you, and to all those of you who have joined us this morning. I think it's been valuable to hear, from you in terms of that realistic way of looking at where we're at now and where we are hoping to get to in the future. Sport for Business is still coming out every morning. Possibly busier than ever before. It's a shame that we can't have those kind of important 5-minute chats that we would normally have were this to be a real life environment, but that will come back. Our next live webinar is on Thursday. We're looking, as I said, at data and measurement in the world of sponsorship. We've got a few specials lined up as well. We're doing an interview this afternoon now, which will be live, or which will be broadcast tomorrow morning as part of the Daily Digest, with Ryle Nugent from Stakeholder Sport, former head of RTE, who'll be able to give us some insight into the international broadcasting scene as it stands at the moment. We're doing our best to keep us all together, and we appreciate your commitment in giving us of your time this morning. But for now, to Paddy, to Derek, to Catherine, and to all of you, thank you very much, and stay safe.
Thank you.
Thanks everybody.
Bye.